Pacific Coast Highway, a road that represents freedom, beauty, and danger all at once. For decades, this stretch between Santa Monica and Malibu has offered postcard views and a tragic reputation. On the night of October 17, 2023, 4 Pepperdine University students were walking along that road. 4 seniors, close friends, days away from their futures. Moments later, a black BMW sped toward them at more than 100 miles per hour. By the time the road fell silent, 4 families had lost their daughters. And a 22-year-old driver named Fraser Bohm faced charges of murder. This is the story of what happened, and why the case may redefine how California treats deadly speed. 4 young, vibrant women, Neve Rolston, Peyton Stewart, Asha Weir, and Deslyn Williams, all seniors at Pepperdine University's Seaver College of Liberal Arts, all members of Alpha Phi. Their bond was sisterhood, late-night study sessions, shared apartments, and plans that stretched far beyond graduation. Her father, David Rolston, remembers the day they chose her name. From the moment I heard the name spoken, Neve was the only choice, he said. And in Gaelic, it translates to radiance. He told the legend behind it, a princess from Tir Nanog, the land of youth, who rides a white horse across the sea. She answered in a sweet and gentle voice, "Noble king of the Fianna, I am the daughter of the king of Tir Nanog, and my name is Neve." To those who knew her, that radiance wasn't myth, it was her nature. Peyton was the big sister everyone leaned on. Her sister Kathleen said, "Sharing a room with Peyton growing up was the best time of my life. Once she left for college, I'd count the days until she came home. It was so much better because I wouldn't see her for a while. And then I would see her for 2 weeks straight, and we were inseparable." Peyton's kindness grounded the people around her. Loyal, patient, steady. Deslyn's energy filled every room she entered. She was loud and bright, one friend said. When she walked in, you knew she was there. Her friends described her as ambitious and fearless, someone who pushed others to speak up and dream bigger. "Making sure that light doesn't die on our campus in any way is so important," a classmate said. Asha was reflective, artistic, and compassionate. She once wrote to friends, "We're meant to love and be loved and share this experience with people. And the ones we choose to do that with will live eternally in our hearts. That's what life, at least mine, is about." Her mother, Vanita Weir, said, "She loved like there was no tomorrow. All in, 100%, always." It was shortly before 9 p.m. when Fraser Bohm, driving westbound in his black BMW, approached the section of Pacific Coast Highway known as Dead Man's Curve. He'd grown up nearby. He knew its bends and blind spots. Behind him was Victor Calandra, a 35-year Malibu resident driving a blue GMC pickup. He noticed the BMW drifting between lanes, occasionally onto the shoulder. Even from 100 yards back, it looked unstable. At the red light near Las Flores Canyon Road, Calandra pulled alongside and saw Bohm with a cell phone between his legs, thumbs moving. Accounts of what happened next differ. According to Calandra's courtroom testimony, he rolled down his window and warned, "Hey, you need to be careful. You're going to hurt yourself." But Calandra's attorney, Robert Helfand, later told Fox 11 Los Angeles that his client actually said, "You're going to kill somebody. Slow down." Whichever the phrasing, the warning came too late. When the light turned green, the BMW launched forward with what Calandra described as extreme acceleration. Its taillights disappeared around the curve. Moments later, Calandra came upon devastation. 3 parked cars were crushed forward onto the shoulder. Smoke filled the air. The 4 students had been walking along that same shoulder moments earlier. Calandra stopped, ran toward the wreckage, and found Bohm in the driver's seat, conscious, bleeding, disoriented. He helped him out and sat him on a low embankment. Another motorist, Miguel Cruchinho, arrived and joined him. He'd seen the BMW moments before, weaving through lanes. Now he saw the aftermath. Bohm kept repeating, "I'm sorry." Both men kept him seated until deputies arrived. By the time first responders reached the scene, Neve, Peyton, Asha, and Deslin were gone. Deputies photographed the road, measured skid marks, and recovered the BMW's black box, a small device that would soon explain the speed, the impact, and the reason prosecutors called it murder. Deputy Robert Apodaca, a veteran crash investigator with the Los Angeles County Sheriff's Department, led the reconstruction. Using a Faro 3D scanner, he mapped every fragment of debris. Then he downloaded the BMW's event data recorder, the black box that silently logs speed, braking, and throttle input. The numbers were damning. 5 seconds before impact, 104 miles per hour. At the moment of collision, 99. No hard braking. The accelerator pressed nearly to the floor. Prosecutors said it wasn't panic, it was choice. Bohm knew the road, knew its danger, and accelerated anyway. In April 2025, after a 3-day preliminary hearing, Judge Diego Edber ruled there was sufficient evidence for trial on 4 counts of second-degree murder and 4 counts of gross negligence manslaughter. To understand why this crash sparked murder charges, you need to understand Pacific Coast Highway itself. For decades, this 21-mile stretch between Santa Monica and Malibu has been both California's most photographed coastline and one of its deadliest roads. The curves are tight, the shoulders narrow, and the speed limit, 45 in most areas, is routinely ignored. Dead Man's Curve, where this crash occurred, earned its name through repetition. Year after year, drivers misjudge the turn. Some walk away, others don't. Local residents have long pushed for safety improvements. Lower limits, better lighting, pedestrian barriers. After multiple deaths, including the 2024 summer Wheaton DUI crash that killed a rideshare driver just months after this one, pressure on authorities to act only intensified. Prosecutors knew this case would be watched closely. They chose murder charges deliberately, not just to hold Bohm accountable, but to send a message. Speed kills, and the law will treat it accordingly. Under California law, a traffic fatality can rise to second-degree murder if a driver acts with implied malice, a conscious disregard for human life. It doesn't require intent to kill, only awareness of the risk and a decision to ignore it. Prosecutors said Bohm met that standard. He knew the road's danger, had lost 2 close friends in high-speed crashes, and still pushed past 100 miles an hour. He knew the risk, one prosecutor said, and he did it anyway. From the start, the defense has argued that Fraser Bohm wasn't a murderer. He was a frightened young man reacting to danger. They claim another driver chased or harassed him that night, forcing him to accelerate out of fear. His first attorney, Michael Kraut, called it panic, not malice. But investigators found no independent evidence of a pursuing vehicle. No witness reports, no dashcam footage, no video from nearby homes or businesses. By early 2025, Bohm replaced his legal team with Alan Jackson, one of Los Angeles' most recognizable criminal defense attorneys. Jackson's arrival signaled a shift in tone and strategy, and a dramatic escalation in visibility. A former Los Angeles County Deputy District Attorney, Jackson made his name prosecuting high-profile homicide cases, including the conviction of music producer Phil Spector for the 2003 murder of Lana Clarkson. After leaving public service, he built a private practice defending celebrities, professional athletes, and Fortune 500 executives. And just months before joining Bohm's case, Jackson successfully won an acquittal for Massachusetts woman Karen Reed, who had been accused of killing her Boston-area police officer boyfriend in a case that captivated national headlines throughout 2024 and 2025. The Karen Reed trial revolved around one question that echoes here. When does recklessness become intent? Prosecutors in both cases argued conscious disregard. Defense attorneys argued confusion, panic, and flawed investigations. In Reed's case, a jury sided with Jackson's reasoning. acquitting her of murder and manslaughter after a months-long trial that exposed inconsistencies in police work. That win cemented Jackson's reputation as one of the most formidable courtroom tacticians in the country. His addition to Bohm's defense sent a clear message. This would not be a quick or quiet trial. It also underscored that Bohm's family had the financial means and determination to mount a top-tier, resource-heavy defense. Jackson immediately attacked the foundation of the prosecution's theory, implied malice. He argued that speed alone cannot prove a driver intended harm. Tragedy doesn't equal murder, Jackson told the court, calling the case a collision, not a crime of intent. He urged Judge Thomas Rubinson to dismiss the murder counts, saying California's own Supreme Court has ruled that high speed, without more, does not automatically show malice.
Your Honor, thank you, first of all, for allowing us to be heard on this. I will try not to repeat myself. Obviously, the court has read our submission, read all the exhibits, the preliminary hearing transcript, but I think that there are certain issues that do bear on the court's ultimate determination, and I'm going to highlight those issues as best I can and as succinctly as I can. And it starts with one truth, a legal truth here in California. Speed cannot be treated as malice. Speed cannot be treated as malice. That is the rule in the state of California. It's not made up by the defense, it's not made up by me. It's not a tagline. It's the rule of law in California recited in a statement handed down to the lower courts by the Supreme Court Justice Kelly Evans. Your Honor, this case has always required one thing only from the prosecution, and that is proof of implied malice. Not proof of negligence, not proof of recklessness, not proof that this was a tragedy, which it clearly was. They must prove implied malice, and the law is crystal clear that implied malice has two separate and independent requirements, an objective requirement and a subjective requirement. The prosecution has never satisfied either of those, certainly not at the preliminary hearing. And I want to be very clear, right now, at least for the first part of my comments, I want to separate those two into different legal pillars. The first thing I want to address is the objective requirement. What act did Fraser Bohm commit that objectively involved a high probability that it would result in death? That's the question before the court. That was the question before the magistrate. What happened on Pacific Coast Highway, I could not be clearer about this, was a tragic collision. But tragedy does not equal murder. And the law does not permit the district attorney to convert a fatal accident into second-degree murder simply by calling speed malice. Because we go back to that first postulate, speed cannot be malice in California. Your Honor, there was no alcohol, no drugs, no testing, no racing, no distraction, no prior DUI by my client, no advisements, no Watson warnings, no statement of indifference after the fact, no criminal history, no driving history, no bad driving history, no serious consequences imposed by the government in a judicial proceeding. Nothing that has ever been cited in the cases where implied malice has been upheld in California. So what are the people left with? What are they left with? All of those no's, one after another, after another, after another, Judge, all of those no's make them rely on one thing, and one thing only, and this is the basis of their entire theoretical postulate. Speed. That's it. Alleged speed at that. Disputed speed. Undefined speed. And now, after apparently abandoning that exact theory, which is what they argued at the preliminary hearing, they want this court to treat speed alone as implied malice, and that is not the law. That brings us to the fundamental problem in their briefing and in the magistrate's ruling. The prosecution has misstated or did misstate at the preliminary hearing the legal standard, and the magistrate clearly accepted that incorrect standard. They collapsed the two prongs of implied malice into one, the two prongs being the objective and the subjective into one prong, and they continue to do so even as recently as their reply. The reply brief that we received this morning states, quote, "The objective and subjective determination of the lethality of speed." That is a direct quote from the prosecution's reply brief from this morning. They still are conflating and combining the objective and the subjective factors, and the law says you cannot do that. And they're doing it on the back of, quote, "the lethality of speed." They go on to say in the reply brief in a two-page reply, in addition to speed, he also lost control of the car. Well, Judge, by definition, every crash involving speed is also going to include the loss of control of the vehicle. Otherwise, no crash. And then they throw in as almost a Hail Mary, And by the way, the defendant, quote, was aware that he did not have full control of his vehicle prior to doing so, end quote. No citation, no quotation to the record, no citation to the transcript, nothing. Just a blatant, bald-faced statement with no foundation in fact. Where is the evidence? What evidence did they produce and present to the magistrate that my client, quote, was aware that he did not have full control of his vehicle prior to doing so, prior to speeding, and prior to the collision? There is none.
Prosecutors countered that this case had more. A driver who knew the road, admitted its danger, and pressed the accelerator anyway. They said Bohm's behavior showed a wanton disregard for the high probability of death.
Had the knowledge. He admitted that he had the knowledge. The issue is, as Mr. Jackson pointed out, does that mean that forever he could be charged with murder if he exceeds the speed limit by a single mile an hour? And the answer is no. Probably not even 5 miles an hour. Probably not 10. It has to be that he exceeds the speed and does acts that demonstrate implied malice. And here, that's exactly what we have. He knew that the speed, and he said that he believed it was 130 miles an hour, caused the death of his 2 best friends. Again, I'm not saying that the number is 130, but he clearly has an understanding that these excessive speeds can result in death. And it's not certainty, it is more than remote, or and I want to get the language right. In one of the citations, and this is from Reyes, citing People v. Cravens, the quote from a concurrence of Justice New, although an act that will certainly lead to death is not required, the probability of death from the act must be more than remote or merely possible. And that is absolutely what we have here based on the totality of the circumstances and the totality of the acts that the defendant engaged in, understanding that he had been driving in a manner prior to the excessive speed that was described as going from all the way to the shoulder, all the way to the other side, that he was engaging in behaviors that already drew the other driver's attention to him. And then, at that point, he decided to speed at such excessive speeds. And when I say excessive, we're talking about the actual speed limit was 43% of the speed that he reached. He was exceeding the speed limit by 231%.
At that same hearing, Jackson renewed a request for access to witness Victor Calandra's phone data. The defense argued those records might prove that Calandra, not Bohm, was the aggressor, possibly following too closely or provoking a reaction. They said GPS and timestamp evidence could show whether Calandra's truck stayed near Bohm's BMW or trailed farther back, challenging the witness timeline. If the data placed Calandra close behind, the defense could claim Bohm accelerated to escape perceived danger. If not, the entire road rage theory collapses. Calandra's attorney Robert Helfand called that claim ludicrous, telling Fox 11 Los Angeles his client merely shouted for Bohm to slow down after watching him drive erratically. Judge Rubinson granted a limited forensic review of Calandra's phone, restricted to the night of the crash. No findings have been released publicly. For the defense, though, the request itself is strategic. If they can raise even a sliver of reasonable doubt about who was the aggressor, they might persuade jurors that Bohm's behavior was negligence, not malice. As that motion over phone data played out, the courtroom dynamic shifted. By this stage, the case was no longer just about one night on Pacific Coast Highway. It had become a test of how far California law could stretch the concept of implied malice. When the defense motioned to dismiss the murder charges, the Van Nuys courtroom was packed to capacity. The families of the 4 Pepperdine students sat closely together behind the prosecution's table, many clutching photos and flowers in Alpha Phi's colors, pink and silver. Across the aisle, Fraser Bohm's family sat silently behind the defense, their faces pale and unreadable. Reporters filled every available seat, with cameras waiting outside in the hallway. For many, It wasn't just a hearing, it was a referendum on how California treats deadly speed. Legal analysts covering the proceedings said the outcome could redefine the boundaries of implied malice for years to come. If the murder charges survived, prosecutors would gain precedent to pursue similar cases where drivers weren't drunk or high, just dangerously fast. If they failed, defense attorneys across the state could point to this case as proof that speed alone isn't murder. At the heart of the argument is California's narrow but critical distinction between gross negligence and implied malice. Gross negligence is carelessness, speeding, distraction, a bad decision made without appreciating the full danger. Implied malice, however, requires awareness, that the person knew their actions could likely cause death, and did it anyway. It's the difference between a momentary lapse and a conscious disregard for life. That line is thin, sometimes seconds thin. Did the driver brake? Were they warned? Had they seen crashes there before? In Bohm's case, prosecutors said every indicator pointed to awareness. He'd grown up on that stretch of Pacific Coast Highway. He told investigators he knew it was dangerous, and the black box data showed not panic or hesitation, but acceleration. The debate has precedent. In 2014, a Fresno County driver traveling 110 miles per hour on Highway 99 killed 2 people. Prosecutors charged murder, and the jury agreed, citing the driver's prior speeding tickets and explicit knowledge that his actions were deadly. 5 years later, in 2019, a driver in Orange County struck and killed a pedestrian at high speed but was convicted only of manslaughter. Pacific Coast Highway has carried tragedy before, even within the Pepperdine community itself. Nearly 50 years earlier, in September 1975, a former Pepperdine University president, M. Norval Young, was involved in a fatal crash on this same road. Driving along the Malibu coastline, Young's vehicle rear-ended another car, causing it to burst into flames. 2 women were killed. His blood alcohol level was nearly 3 times the legal limit for intoxication at the time. He later pleaded guilty to vehicular manslaughter, receiving probation and a requirement to participate in alcohol education outreach programs instead of jail time. Defense attorneys pointed to that second case, arguing that Fraser Bohm had a clean record, no substance use, and no prior arrests, the hallmarks of a tragic accident, not murder. Prosecutors countered that his knowledge of Dead Man's Curve and history of losing 2 friends to high-speed crashes made the distinction clear. He knew better, and did it anyway. Beyond the legal debate, the hearing drew widespread attention for what it revealed about privilege, perception, and accountability in Malibu. Some residents and online commentators referred to the case as Malibu's reckoning. A young man from a well-connected family, free on bail and represented by a high-profile attorney, facing trial for killing 4 promising students who came from across the country to chase their dreams. Critics asked how many defendants charged with 4 counts of murder could walk free pending trial. Supporters of the defense replied that bail isn't a punishment, it's a constitutional right. But for the victims' families, seeing Bohm enter and leave court as they mourned felt like another loss. Inside the courtroom, Jackson's team continued dissecting the prosecution's evidence. They challenged the calibration of the BMW's event data recorder, the black box, questioning whether the vehicle's airborne moments during the crash could have distorted the readings. They introduced their own accident reconstruction experts to analyze road width, shoulder design, and lighting conditions at the scene. Their argument? The crash was tragic, but the environment itself was unforgiving, a dangerous curve long known to city planners, not proof of malice. Prosecutors countered that blaming the road missed the point entirely. Yes, Pacific Coast Highway is dangerous, but it didn't press the accelerator. It didn't ignore the speed limit or the warnings from another driver. People drive that same curve every day, they argued, and most make it home safely. This wasn't about infrastructure, it was about a decision. Their closing words focused on responsibility, not only for what happened that night, but for what kind of message the court would send. If driving 104 miles an hour on a road known for fatal crashes wasn't enough to qualify as implied malice, they asked, then what would be? The defense sat silent as the courtroom grew still. Family members of the victims held hands, waiting for a ruling that would decide whether this case would move to trial or end here. Alan Jackson leaned close to his client. Across the aisle, prosecutors shuffled their notes, eyes fixed on the bench. For a long moment, Judge Thomas Rubinson said nothing. Then he began to speak. On November 10th, 2025, Judge Rubinson denied the motion to dismiss. He ruled that Bohm's familiarity with Pacific Coast Highway, his awareness of previous high-speed fatalities, and the lack of braking or evasive action before impact were enough for a jury to decide whether implied malice applies. When Judge Rubinson finished speaking, the room stayed silent. For a moment, no one moved. Then the weight of his words began to settle. This case would go forward. 4 counts of second-degree murder. 4 counts of gross negligence manslaughter. A trial that will ask 12 jurors to decide where negligence ends and malice begins. Outside the courthouse, families of the victims gathered briefly in the hallway. They didn't celebrate. They simply nodded to one another. Another small step in a process that still feels impossible to many of them. Across town, legal analysts called the decision a defining moment for California's handling of deadly speed. If the charges hold through trial, it could mark a shift toward stronger accountability, a message that extreme speed will be treated not as misjudgment, but as a conscious act of disregard for life. The next hearing is set for January 2026, where both sides will finalize pretrial motions and jury selection schedules. A trial date could follow in the spring. Until then, Fraser Bohm remains free on bail, required to appear at every hearing and avoid any new infractions. His defense team has continued reviewing technical data from the BMW's event recorder and the limited phone records granted by the court, while prosecutors prepare to present the case before a jury. At Pepperdine University, the legacy of this loss remains visible. 4 empty chairs stood at the class of 2024 graduation ceremony. Each bore a cap and gown, and each name, Neve Rolston, Peyton Stewart, Asha Weir, and Deslyn Williams, was read aloud as their classmates rose in silence. The university awarded them posthumous degrees, honoring the futures that ended too soon. For their families, justice won't come from a verdict alone. It will come, if ever, from a world that learned something from their daughters' deaths. Pacific Coast Highway will keep winding along the cliffs, beautiful and dangerous as ever. Every mile tells a story of freedom, of loss, and of how fragile the line between them can be. I will continue to bring you updates on this case as it progresses. Stay safe, everyone.